Hi, welcome everybody. Thank you so much for deciding to spend the next 45 minutes with Rutger and I and the amazing ICW team. We're going to get started because this is a really hot topic. I was trying to think of a better word than hot topic, but I think that's probably the best way of describing it. It's something we've been talking about for quite a few months. So really excited to discuss this with Rutger today, for Rutger to present. Really quickly, if you've been on these webinars before, you'll know the drill with this. Please, your line should be muted anyway. Please actively participate. We'd love to hear from you. I put the Menti in the chat just for those of you that joined a bit earlier, and I can see you're filling it out, which is really, really great. It's useful for us to get an understanding of how much you know and any questions that you have. The chat function and the Q&A function should both work, so please do ask any questions in there. If we don't get to answer them in the next 45 minutes, we will follow up with you and hopefully get any answers to any questions that you have. Also, any questions, eMarketing@ICW on the slide. So let me briefly introduce ICW and then I'll introduce myself. So ICW is an amazing organisation that I work with. It really takes the headache out of the admin of compliance. And I work with the amazing team at ICW who help with multiple queries that I have about compliance, about testing, about inspections. There are over 60 employees at the ICW team and over 3,500 clients. So as mentioned here, it's a professional team of compliance experts, and it's kind of like the TIC, so the testing, inspection and compliance Alibaba. Any questions that you have about ICW, feel free to contact me directly or Rutger or any of the ICW team. Okay, really quickly about myself. If you've been on some of these webinars before, you've probably met me before, so welcome back. Really briefly, I'm a product safety expert, been working in product safety for 20 years, over 20 years, lots of training with many participants on lots of different training sessions. And I'm also the technical author of a few British standards. Also worked on some EU international based projects. And most recently, we've worked on the Business Certificate of Competency in Product Safety, which is an amazing training session. Someone's just asked in the chat, great question, will there be a recording? This is being recorded and it will be available on the ICW website, as are all the other recordings that we have. So great question and thank you. Okay, so the Menti is available here and people are already completing it. Just so you know, Rutger, the kind of audience that we have today, there's a few that are saying basic understanding, which is great. There's one person that's answered that they're fully prepared, which is amazing. I'd love to hear from them.
Yep.
How they're fully prepared. And then some thoughts about the GPSR impact, complicated, concern. So some interesting things, which I think we can hopefully help people with today. So as you can see on the screen, we've got the website that you can access, but also the QR code that you can use your phone to scan. And just let us know if you have any comments. In the Menti app, it's anonymous. So if you want to put any thoughts in there, then we don't know who it's from if you'd rather be anonymous. But of course, you can use the chat function. And I'll keep an eye on that while Rutger's talking and interject and ask Rutger any questions. Okay, over to you, Rutger.
Thanks, Geraldine, and good morning, good afternoon, or good evening to all the participants. Thanks for making time for joining this webinar. Just a few words about myself. I'm a lawyer by background and education. I built most of my legal career as an in-house lawyer at Shimano. I think it's a well-known brand for bicycle components and fishing tackle. And 4 years ago, I started my own company, Recall Desk. And I'm a proud partner of the World Federation of the Sporting Goods Industry. I also regularly write blogs and articles for various media. I'm a member of several standard committees. And recently, I also started a company called Europe. And with that company, I'm offering authorized representative services, also partnering with the ICW. So that was the commercial part. Let's start the webinar. As Geraldine already mentioned, we've organized previous webinars as well about the same topic. which you can find on the website of ICW. So there's a library of webinars that you can visit and see. So this is partially a repetition, but we are also trying to give you an update on any news or whatever kind of developments on the GPSR that we think can be relevant for you. What is also interesting is that the European Commission now has published their webinar. It's a very recent one, 30 January 2025. So I think it's I can really recommend to watch that webinar as well, because of course it's directly from the European Commission. So really interesting. The agenda for today's webinar. So the latest news on the guidelines that we are all expecting to be published on the GPSR. Then an overview of the highlights of the GPSR, which is to a large extent a repetition of previous webinars. So I will try to go over a bit quick, but if you have any questions or want to deep dive, let's see if we can do that during this webinar. Otherwise, we can take that offline after the webinar. Then on 3, while the dust settles, some food for thought that I would like to share with you. And also here, I invite you to share your comments or your thoughts or views on the topics that I want to share there. And then we will end with the key takeouts of this webinar. So on the latest news on the guidelines, we are actually still waiting. So they were promised to be published already last year, September, then it was October, then November, then December. And I literally have an email from an employee from the European Commission promising me that it would be published in January. Well, here we are in March and they're still not there. So I'm not sure what's happening, but yeah. We were hoping they would have been published already in January, so we could also include that in this webinar, which was of course already planned months ago. But unfortunately, we cannot reflect on the guidelines. So that is a pity, but yeah, hopefully next time, because we will obviously continue giving these webinars on a regular basis on the GPSR. So then, continuing with the second part on the highlights, I always start that part of the webinar with this simplified overview. So if you sell products in the EU, consumer goods, what you want to do is really check if there's any specific union harmonization legislation applicable to your product. That's basically where you start, right? Whether it's toys or electronics or what have you, machinery, doesn't matter. You should really check if there's any specific union harmonization legislation applicable. And it can be multiple pieces of laws, actually, mostly often that is the case. Ideally, there are also safety standards that can help you design your product and test your product in line with that harmonization legislation. But if your product, or for specific risks that are not covered by that harmonization legislation or the safety standards, or for products that are not covered by such legislation, we still have the general product safety regulation in place, which is functioning basically as a safety net. So, and that's really what this webinar is about. It's about, or mostly about, the general product safety regulation. That is what this webinar is about, mostly. So, about that piece of law, it started to apply already on 13 December 2024. I hope most of you, if not all, are aware of that. It used to be the General Product Safety Directive, but that one is now replaced by the General Product Safety Regulation as of 13 December 2024. Indeed, it's a regulation and not a directive. What is the main difference? A regulation has direct effect in each member state of the EU versus a directive which needs to be transposed into national laws. So that is not needed anymore with this regulation. So it is already applicable directly in each member state of the EU, and it does not need to be transposed into national laws. The scope, interestingly, it's called a general regulation, but it really contains quite some detailed and specific provisions, especially if you compare it with the directive. So that is really new. And that's also why I call it a safety net plus. So those are my own words, but because of those quite some detailed and specific provisions, I think it's a safety net plus. As a side note, the regulation will also cover food imitation products, repealing the directive that you can see over here. All right. So then for the highlights or the key requirements, the GPSR is going mental. So what do I mean by saying that? Under the GPSR, the term product safety takes on a much broader meaning and also includes health. And the GPSR actually refers to the World Health Organization's definition of health, which is a state of complete physical, mental, and social well-being. So not merely the absence of disease or infirmity. And this is, I think, really a game changer. Another game changer, and this is where the GPSR aligns with union harmonization legislation, because it stipulates that if you sell consumer goods to the EU and they are not covered by union harmonization law, basically it says, yeah, but still you also need to have technical documentation in place, and that includes a risk analysis. And for most or a lot of products that are covered by union harmonization legislation, that is already the case, or let's call it CE marked products. You're probably already familiar with this concept of having technical documentation, even having a declaration of conformity. Well, that's not the case for the GPSR. You don't need to have a declaration of conformity, but you do need to have technical documentation in place, including a risk analysis. So it really aligns here with union harmonization legislation. And I think that is really a key aspect of this piece of law. If you do a risk analysis, depending, of course, on the type of product, now you should also be aware that you may have to include mental health as well in your risk analysis. Of course, that depends on the type of product, but that is, this a new element that you need to be aware of. I earlier referred to the webinar that was given by the European Commission earlier this year, and it actually includes this model template of a technical documentation, or what the EC thinks a technical documentation could look like. It's pretty basic. I think it's very basic, but I think it's helpful. Hopefully in the guidelines they will they promised really to publish a more details and the template and more information on how the technical documentation should be built. But this is a starting point, so I thought it was good to include it in this webinar because it's new, and I think it can be helpful for a lot of companies who are struggling with this, for whom having technical documentation is really something new. Another game changer and another aspect where the GPSR is aligning with union harmonization legislation is that if you are based outside the EU, selling directly to the EU, you need to have a responsible person in the EU. So again, for a lot of products that are covered by union harmonization legislation, this is already a requirement. But until 13 December 2024, that was not the case for a lot of other products that were sold in the EU. And now the GPSR is basically aligning that requirement also for those products, which makes sense, right? Let's be honest. Yeah, so I think that is the key message of this slide. So could that mean in practice? So let's take this example. You're a manufacturer based in, let's say, the US, and you sell directly to consumers in the EU. You can no longer do that if you do not have a responsible person in the EU. To solve that, you could, for example, appoint an authorized representative in the EU. So then that authorized representative would operate on the basis of a mandate and actually be regarded a responsible person in terms of the GPSR. So that is how you could solve this issue. Then the details of the manufacturer and the AR should be on the product or in the packaging. So be aware that this is a requirement. Besides next to the details of the manufacturer, you should also label the product or the packaging or the manual with the details of your authorized representative. And this is really low-hanging fruit for authorities. So if they can't see any details of an authorized representative or a responsible person, that is a red flag basically, and so be aware of that. So this is another practical example. Many companies are organized in this way. So again, let's say you're a manufacturer based in the USA and you sell your products in the EU to a variety of different economic operators, right? You may sell to a number of importers. You may sell to distributors. You may sell to retailers who then, in fact, should also be regarded an importer, because if you sell directly to a retailer in the EU, basically that retailer is also operating as an importer. So basically, that's what I'm saying here. They all qualify as an importer in terms of the GPSR. And so that comes with a lot of responsibilities. Actually, they operate as a quasi-manufacturer in terms of the GPSR. The details of both the manufacturer and the importer should be on the product or in the packaging. So here, there is no authorized representative. This is the example where the manufacturer would sell these products to either an importer or a distributor or retailer, and they are considered a responsible person by default. So you don't need to appoint them. They are a responsible person automatically based on the GPSR.
We've been asked a question, Rutger. Sorry, I
Yeah,
hope you don't
sure.
mind me interrupting there. And this might be a tricky one.
Yeah.
So can the responsible person be based in Northern Ireland? What do you think about that?
Yeah, that's always a tricky one.
Yeah.
You have to help me here. That is part of the EU, right, or not?
Yes, so
So
I actually think the answer is yes
yeah, if
on
it's
that
the
one.
EU,
But
then that's okay. Yeah,
yeah, I think in Northern Ireland is a very interesting situation.
yeah.
But I think the responsible person can be based in Northern Ireland. I'm up for being corrected by anybody at this stage, but that's my
If
thought
it's
on
if
that one.
if
But
it, if it's the EU, and that's always a bit tricky. But if it's the EU, so it should be based in the EU, and that is the key requirement. So then the answer
perfect.
would be
Thank
yes. That's fine. Yeah. Okay. Um, yeah. So. And these are just question marks. I do not have the answer to all these questions. But for example, I faced situations where a manufacturer didn't want his importers, there were a number of them, or retailers to function or to operate as their responsible person, because it comes with a lot of responsibilities, including labeling the products, including having the technical documentation for 10 years, etc., etc. So it comes with a lot of admin and a lot of burden. So is it possible to replace the importers by or release them from their obligations under the GPSR by appointing an authorized representative? I'm not 100% sure about that. And I've watched the webinar of the EC, but yeah, hopefully the guidelines will give some more guidance and clearance on that. To be honest, I think it would make sense. But looking at the text of the GPSR, I would say the answer is no. So hopefully the guidance will give a bit more flexibility here. But let's see, it's still for me a question mark. So yeah, and then there's another complicating factor. There is a new EU product liability directive coming our way. The text, everything has been improved now, approved, sorry. It will start to apply, I think, in 2 years from now. And pursuant to this directive, the responsible persons, let it be an importer, a distributor, or even an authorized representative, can be held liable under that product liability directive. So being a responsible person under that liability directive comes with a lot of you're really exposed, so it comes with a lot of exposure there, and yeah, that can be challenging. And also, you know, your importers or retailers in the EU may not like that. So again, here, what kind of solutions are is the EC thinking of? So that is a complicating factor. And again, hopefully the guidance will clarify a bit more about that. Then online platforms as the new market surveillance authorities. So there's a whole new section in the GPSR, and this is also really a game changer if you compare it with the directive. And the providers of online platforms, Amazon and the like, if you will, must ensure through a battery of due diligence obligations that traders using their platform only sell products that comply with applicable laws and regulations. I think, to be honest with you, this is the biggest trigger for companies to find out that actually there is a piece of law called GPSR, because so many companies are selling their products through these platforms. And basically that was a huge wake-up call for those companies that, yeah, if you want to continue trading your products through those kind of platforms, you have to make sure that you are compliant and meet the requirements of the GPSR. And that may include having an authorized representative as well, or at least have a responsible person, because and you can check that on Amazon and the like. You can now see with the offer of the product, with the product offer, all kinds of information, and that includes who is the responsible person in the EU. So I think that makes providers of online platforms de facto a new or a extra kind of gatekeeper when it comes to product compliance, if you will. But also for, let's call it, regular online offers, if you sell your products through your web shop directly to the EU, also here there are some requirements, and that includes displaying who is your responsible person in the EU, and you should also make available or at least highlight what are the safety warnings, what is the safety information of related to your product. So I think that is also really important for economic operators to know if you're based outside the EU and selling online products to the EU. Labeling requirements, it's not entirely new. If you look at the directive, that already included similar kind of obligations. There should be, in terms of traceability, manufacturers should ensure that their products can be traced either through a type, a batch, or a serial number, or any other kind of element. They should also put their name and their address and details on the product, or if that's not possible, on the packaging or on the manual. Also, importers should do that. What is really new is that it includes an electronic address, and a lot of discussion. This triggered a lot of discussion, like what is an electronic address? Is that a website? No, it's not a website. That's not enough. It should either be an email address, or it should be a link, a direct link to a contact form, for example, an online contact form. You can also find some more information about this in the Q&A document that is also published by the European Commission if you look for the GPSR on the EC's website. So that's that for labeling requirements. So in that sense, it's not really new. What's really new is be aware of the electronic address that should be added. And also here, this is low-hanging fruit for authorities. So if they can't see an electronic address on your product or packaging, that is a red flag, right? Internal product safety processes. So I think this is really positive about the GPSR, that they really pay attention to having internal product safety processes in place. Interestingly, if you read recital 37, it says it's compulsory to have those processes, but if you go to really the articles and the sections of the GPSR itself, it's in a section that is not compulsory per se. So it really depends if, for example, your product is covered by union harmonization legislation. So it's an interesting flaw, so to speak, of the GPSR. Of course, it really depends on the type of business and the type of product. So it really should be determined by the economic operator itself, and also in terms of their role in the supply chain, how to organize your internal product safety processes. Luckily, you don't need to reinvent the wheel all by yourself. There are standards out there that you can use and that I can really recommend to check and to use, basically. I mentioned here ISO 10377 and 10393. They are very similar to the UK PAS 7050 and PAS 7100. The UK standards, they are free. You can download them free of charge, which is really good. I'm really happy about that. ISO, unfortunately, you have to buy. But it's really worthwhile checking these standards and use them to your benefit, right? And doesn't matter the size of your company, if you're big, small, medium-sized, it's really helpful. Yeah, just to summarize this slide, we were all hoping that we could use a QR code to basically pass on information to consumers, and therefore not needing to have very thick booklets in your packaging accompanying your product with 25 or how many languages of information. Unfortunately, the GPSR does not allow for a QR code as a single means to do that. You can, of course, use a QR code in addition to, but unfortunately, the GPSR still requires to have certain information on paper or on the packaging or on the product. So unfortunately, this is not possible. And I'm sorry to be the messenger of this. Get a lot of questions about it, so that's why I thought it was good to mention this. Yeah, this is, I think, really a game changer. The GPSR now requires companies to manufacturers, but also other economic operators, like, for example, importers. They also play a role. If they are aware of accidents, they should report that to the manufacturer. But ultimately, it's the manufacturer that needs to report without undue delay accidents caused by their products that they have placed on the market. Lots of discussion about, okay, but how to define an accident. Luckily, there's now finally some guidance and clarity on that. It pertains only to incidents resulting in death or serious adverse effects on health and safety. Those accidents should be reported to the competent market surveillance authority of the member state where the accident occurred. So be aware. I think this is really a game changer. Make sure that you have your internal processes in place so that you are able to be aware to start with that your products are involved in accidents, and then also have an internal process in place, to verify if that accident needs to be reported or not. So, in terms of recalls, a new requirement is that you at least have to give consumers the choice of at least 2 of the following remedies: repair, replacement, or a refund. And only if it's impossible or disproportionate, you're also allowed to offer 1 remedy, which of course leads to the discussion, okay, what is impossible or what is disproportionate? But luckily, there is this flexibility built in this article. But be aware of this requirement. And then also, where economic operators, like a manufacturer or an importer or a retailer or Amazons and the like, have in place product registration systems or customer loyalty programs, enabling the identification of products bought by consumers for purposes other than contacting their customers with safety information, they shall offer the possibility to their customers to provide separate contact details only for safety-related purposes. Yeah, it's an interesting one, and not per se really very, striking if you read the text of the GPSR, but then at the end of the text of the GPSR, suddenly somewhere this clause is included, which can, I think, have quite some impact on you as a company. So I thought it was good to include this in the slides, that you are aware of this. I'm not sure if authorities, regulators are really going to monitor this or how they are going to do that, but still, I thought it was interesting to include that in this presentation. Consumer
I've noticed,
complaints.
I just wanted to highlight there, sorry, Rutger, that so I mean, I shop a lot, I probably shop too much, but on my Amazon profile, if you go to your profile, you can actually look and see any of your previous products that you've bought if they've been subject to a recall or corrective action. So I thought that was quite interesting, and I think as consumers, we're all consumers, we have to take responsibility here, and if you are being alerted to it, please do act on it. Where that information comes from anybody, by the way, but I think it's, yeah, it's challenging, but
Yep. Thanks, Geraldine. Another game changer, I think, is that well, we have the Safety Gate portal. I guess you're all aware of that, and now they are really building, redesigning that portal, and also now add a portal specifically with the purpose for consumers to enable them to submit complaints with regard to products. So yeah, what does that mean? Yeah, well, I think we will all understand that as a manufacturer, you will be a lot more exposed if that starts to happen, right? If there is a facility actually really for that purpose only. And yeah, I was just thinking, what if a consumer reports an accident, but the manufacturer didn't? What kind of consequences would that have? So yeah, I think it's quite a game changer. And I think, again, it's important for companies to have those internal processes in place to avoid this from happening, right? That a consumer actually reports an accident and you as a manufacturer didn't. So be aware. Penalties, basically no big change as compared to the directive. It's still for each member state to decide. Still, so yeah, I think that's it. Also, for the sake of time, I will not go into detail here. So then, coming to part 3 of the webinar, so the food for thought while the dust settles, so to speak. And yeah, feel free to comment, share your thoughts in the chat. Yeah, really curious to hear your thoughts. And here I'm starting with a copy of a slide, again, taken from the webinar of the European Commission. And it's a slide about the interaction with harmonized legislation. I think we spoke about it before in this webinar. And here they are basically listing the chapters that are applicable to harmonized products. So even if your product is covered by harmonized legislation law, like toys or machinery, there are chapters in the GPSR that are, in addition to that, also applicable to your product. And they're basically listing those chapters here. Chapter 1, Chapter 3, 4, 6, 8. And then Chapter 2 is only applicable to harmonized products for risks not covered by EU harmonized legislation. So really, here they mean it's really GPSR is a safety net. So Chapter 2 is really that safety net. What I want to highlight here and focus on is one chapter in particular that they are not mentioning here, and that is Chapter 3, Section 1. It is not, interestingly enough, it's not mentioned on this slide. So if you look at Article 2 of the GPSR, it says the following: with regard to products subject to specific requirements imposed by union harmonization legislation, as defined in Article 3, blah, blah, blah. And then look at the bold, Chapter 3, Section 1 does not apply. So that is interesting. I interpret this text that this is not meant to be a safety net. No, it says very black and white, if your product is covered by union harmonization law, Chapter 3, Section 1 does not apply. And again, feel free to comment. I'm really curious to hear your thoughts. Now, if you look at Article 3.27, what they mean with union harmonization legislation means union legislation listed, and this is perhaps a bit legal, but it refers to a specific regulation, but it also says, and any other union legislation harmonization. So basically, it doesn't matter what kind of union harmonization legislation, if your product is covered by union legislation, harmonization legislation, Chapter 3, Section 1 does not apply. But what does that mean? That basically, because we have REACH, right? So chemicals. There are so many. There's so many union harmonization legislation. I can't think of a product that is not covered by it. I mean, there are products out there that are not covered by it, but most of them will be covered by one piece or a lot of them. So my question here is, does that make Chapter 3, Section 1 obsolete? And that is an interesting question, because that is the section that includes the obligations of the economic operators for the manufacturer, the importer, the distributor, the authorized representative, even having a responsible person in the EU when you're based outside the EU. So having technical documentation, doing a risk analysis, it's all in Chapter 3, Section 1. So is this a flaw in the GPSR? I don't know. But again, please share your thoughts if you have them. Does that mean you should act like if it's obsolete? No, that would not be my advice if you were my client, right? I think we all understand what we should do to sell safe products in the EU. We know that this is the spirit of the GPSR, so don't take this as an advice that Chapter 3, Section 1 is not applicable. That would be very risky business. But I think it's a fair question, and perhaps this is a flaw in the GPSR. Unfortunately, I mean, yeah, it was not necessary. Standalone software, another interesting one. Perhaps you've seen the draft versions of the GPSR. There were lots of discussions going back and forth, and if I remember correctly, in one of the draft versions, standalone software was included in the scope of the GPSR, but now in the final piece of the GPSR, it's not mentioned. So you can look for the word software in the GPSR, and I cannot find standalone software. So is it covered or is it not covered? Well, according to the European Commission, it's covered. So they already published some Q&A Also, if you check their webinar, they will say that standalone software is covered. So, but yeah, it's interesting because the GPSR itself is not really clear about it. Then again, if you look at the new product liability directive that is coming our way, standalone software is covered. And typically the GPSR and the product liability really interact with each other. So yeah, I think it makes sense to take the position that standalone software is covered. But it leads to interesting questions like, do you need a responsible person if you're offering software in the EU? Or can social media or web shops be dangerous under the GPSR, right? I think it's very interesting questions. And I think it's pretty likely that I would answer these questions with a yes, to be honest. And that is, I think, very interesting. And I also welcome it. I'm happy about that, right? But yeah, food for thought. Yeah, another interesting one. This is literally in the GPSR, and in the event of a recall, the consumer must be instructed to immediately stop using the affected product. So that is one condition and this applies to all products. Also, if your product is covered by harmonized legislation. And in addition to that, it says that in the event of a recall, the economic operator must collect the unsafe product from the consumer if it's not portable. Well, that's very interesting because how to implement that in practice? How about a car, for example, or an e-bike? I've checked that there are many car recalls in 2025 already, and none of them includes a stop using your car immediately notice. And I'm sure that the car will not be picked up at the consumer's home. So what does that mean, right? Because cars are affected by the GPSR. So it's an interesting one. And I'm just curious to see what the guidelines will say about this, because the GPSR itself does not provide any flexibility with regards to these requirements. But yeah, let's see if the guidelines will do. Also, the recall notice template, which you must use, it's mandatory, also does not provide for any flexibility, because also here the stop use notice is included in this template. So yeah. I think almost last but not least, I think we're also almost done in terms of time, but a very interesting one. There is a Commission delegated regulation published already last year. It's very hard to find online, to be honest. Yeah, now if you start Googling on regulation 2024, blah, 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 you will find it. But if you go to the European Commission's website where the GPSR is published, there is no information about this regulation. Whereas I think it's really important because it basically introduces some new, how to say, changes in terms of the I call it the RAPEX guidelines. So there are guidelines out there that help market surveillance authorities doing a risk assessment if they suspect a product to be unsafe. So there's a whole methodology that they must use. There are 4 risk levels: low, medium, high, serious, and depending on the risk level, you can determine what corrective action would be proportionate. Now, this delegated regulation gives the regulators a lot more power to assume serious risk without doing a risk assessment. And that is basically what this slide and the next slide is saying. And I think that is concerning. I was always happy that in the EU, we still have these guidelines as a kind of checks and balances, as compared to the US, where the CPSC can just say, we think this product is unsafe and we think you should do a recall, period, right? We still in the EU, we have these guidelines that at least, give you some objectivity, so to speak, in terms of what kind of risk are we talking about. Of course, you will still have a lot of discussion with authorities, and I have discussions with them often because I really think they often lack skill to do a risk assessment properly. But at least you have something to discuss about. You have this methodology, right? But with these new powers, where regulators can just assume a serious risk without doing a risk assessment, that is concerning to me. That is worrying. And you can read the text later. I will not read over it, but this bullet point gives an example where they are allowed to do that. And here there's another example where, for example, if as an economic operator you decide voluntarily to recall a product, or where an Amazon would do that, for example, then suddenly a regulator can assume a serious risk with all consequences that will follow. So, yeah, as I mentioned already, my experience is that regulators today already often lack skills to carry out a proper risk assessment. And now, regulators may assume serious risk even without doing an individual risk assessment. So that is really concerning. Yeah, time will tell how this will develop. So, key takeouts. I think we will all agree that in many aspects, the GPSR is really a game changer. And despite the good intentions of the European Commission, it is regrettable that, yeah, certain flaws exist. But despite these flaws, as I already mentioned before, to sell safe and compliant products in the EU, it is highly recommended to follow the GPSR. So have your technical documentation in place, your pre-market risk assessment, a responsible person. So all the requirements that are in Chapter 3, Section 1, yeah, I highly recommend to have them in place to avoid any issues. And yeah, assumption of serious risk by regulators is a big concern. Time will tell what this will mean in the future. So yeah, I think that's it for today's webinar. Wow, where we are.
We've overrun a little bit, but I want
Yeah.
to carry on talking for a few minutes if it's okay with you, Rutger. And I think,
Yeah,
if people
sure.
need to leave, the recording will be available. But I think this just demonstrates it's very tricky to condense this in 45 minutes. But I think you've mentioned risk assessment quite a lot, and I think it's amazing. The ICW team have already thought about this. So we have a webinar on May 7th on risk assessment, and I'm really excited to talk about that serious risk, because I do agree with you. I think some of the points that they've assumed serious risk are quite interesting, and it actually is different to what the PRISM, so the GB methodology, has in there. However, I think it's interesting, especially for chemicals. It's really tricky to risk assess chemicals. So that automatic assumption for chemicals is the same in GB and in Europe in this regulation, because the questions come in about jewelry and chemicals. So basically, the market surveillance officers, both in Europe and in GB, will assume if it doesn't comply with chemical requirements, it is a serious risk. However, what's clear in the GB, so the Great Britain PRISM methodology, is that it's rebuttable. So by that means you can have a discussion, but in my opinion, you would need a chemical expert or, a toxicological risk assessment to be able to explain and go to the depths of, exposure limits per day, etc., for, to prove that it's safe. But I think the foundation is a great one to start off with chemicals, that we can automatically assume a non-compliance is serious risk for chemicals. So I wanted to mention
basically also already the case if you read the current guidelines, the EU guidelines. Basically, it says the same. If it's chemical risk, almost in any case, it's already a serious risk. So, yeah.
Yeah. And I also wanted to mention that, so someone asked about in the Menti, they were talking about UK vague, but EU's clearer. I want to be really clear on this, that so we talk about Great Britain. Great Britain doesn't include Northern Ireland. Northern Ireland is a little bit of a complex situation. So I just want to highlight that. And fundamentally, GB, the General Product Safety Regulation, the EU version, is not applicable in GB. But we do have something called the Product Safety and Metrology Bill, that's come out that is an enabling act that I think will hopefully deal with some of these differences. But fundamentally, like you said, Rutger, and I totally agree, the spirit of it is to save products. So just try and do the best that you can do with the facilities, the team, the the finances that you have to sell safe products. Fundamentally, is what we're saying here. So I think that's it. We'll close the webinar now, unless there's anything else you wanted to add, Rutger. I think
No, not really.
no. Brilliant.
No.
Well, I've loved the interaction. I've loved people have tried to answer some of the questions coming in as well, and the
Okay.
discussion has been really, really interesting. So thank you so much for your time today, and hopefully we'll see you again on another session. Thanks so much, Rutger, as well. As always, I love listening to you present about this topic. I think it's so interesting. So thank you so
Thank
much,
you.
Rutger, and of
Thank you for
course,
having me.
ICW.
Yeah.
Thank you.
Thank you
Bye,
all.
everyone.